Are we live?
All right. Hi, everyone. Welcome to our live stream today. I'm going to be talking about final merits. It's something that has come up in a lot of EB1A consultations recently. I think the emphasis on final merits is definitely something that was weighing heavily on everyone's minds right now. I think there's also rumors going around about an uptick in final merits, RFEs and denials and NOIDs and that kind of thing. I will say I haven't seen a huge uptick in any of that. We've always received periodically a NOID here or there based on final merits, or a denial where they gave you at least 3 criteria and then still denied the case. So it's not like this is anything new, and I'm not sure how widespread the trend is right now to issue a challenge to a case on final merits. But since it's been out in the popular conversation, I figured I would discuss it with everybody here. Right now, the test for EB1A is a 2-pronged test. First, you have to show that you meet 3 out of 10 criteria, and second, you have to demonstrate that you can pass a final merits analysis and prove that you do have extraordinary ability, sustained a claim, and have risen to the top of your field. This 2-pronged test was set out in a court decision called Kazarian. It's not a Supreme Court decision, so it's not necessarily something that is a precedent decision for all courts everywhere or the law of the land or anything like that. But USCIS has adopted the analysis that was put forth in Kazarian as the primary interpretation that they're using to adjudicate EB1A petitions. I am definitely of the opinion, and many other attorneys are also of the opinion, that the way they adopted the Kazarian standard was not done properly according to notice and comment rulemaking. So we actually don't agree with the 2-layer analysis at all. Prior to Kazarian, it used to be that you had to meet the criteria and there was no affirmative final merits burden on the petitioner. Instead, USCIS could deny a case if someone was clearly not extraordinary, or if there were major questions about the veracity of the evidence that they presented, or any issues or inconsistencies in the record. So the final merits check was more of a mechanism that the government could use, not an affirmative burden of proof. It was like a safeguard and not an additional requirement. Under Kazarian, though, it is an additional requirement that you have to meet. And this makes it all very, very fuzzy. Whenever we get a final merits challenge on a case, it is a little bit like working with the NIW standards, where USCIS can say, oh, there's a very high standard and you just didn't meet the level or reach that standard. But if they never define what that standard is, they never give you a real chance to prove that you meet the standard. So there are some court challenges going around for this challenge now, or for this standard now. I expect more court challenges to come around in the future. We'll see how everything lines up with regard to that. But for now, when you're presenting your EB1A case, it is very important to prove that you meet the final merit standard, to prove that you have extraordinary ability, and to prove that you have sustained a claim in your field. So I think the main question is, how do you prove this? I will say USCIS doesn't know how you prove it, because in their policy manual, they say you shouldn't go line by line down the criteria and say, okay, how impressive is this? How extraordinary is it? But that's what all of the officers who issue NOIDs or decisions on final merits do. So the actions they're taking are totally contrary to what is laid out in the policy manual, leaving us all here to wonder, what exactly do they want? What exactly do they need? So instead of it being more of a legal analysis, this is really a reasonability analysis, right? Like when you are looking at final merits, you should not be looking at it as meeting certain criteria or checking boxes off the list. Instead, you should be looking at it more as an explanation that any reasonable, average, normal American would accept for why you are extraordinary, what puts you at the top of the field. And to do this, you should ask questions like, what do people admire about me? Am I in an enviable position? Have I worked really hard and accomplished things that are extraordinary, undeniably? Have I done a lot of different activities? Is there one thing that I can point out in my profile that makes me extraordinary? You should really think through all of those factors. Additionally, final merits is not a place where you want to put extraneous evidence or just dump all of the factors that didn't fit into the criteria. If you do it that way, you inevitably end up emphasizing things for final merits that are not extraordinary. Like if you have awards that didn't meet the awards criterion and you try to claim those for final merits, if they didn't meet the awards criterion itself, they definitely don't meet the final merits criterion, right? Because it's not about volume of activities or anything like that. It's about real prestige, real recognition, some kind of real evidence that you have top expertise, that you have risen to the top of your field. So normally, I recommend that people really re-emphasize the key points from their anchor criterion under final merits. If the strongest aspect of your case is the fact that you are holding a really high-level, critical, important role at a major organization, you should be highlighting that front and center for your final merits. You shouldn't be including all of these random media or awards that don't matter. You should be re-emphasizing the things that do matter. And then secondly, for final merits, I think that expert testimony is super important. And I know that doesn't always come through in USCIS decisions or AAO appeals or anything that you see written, according to all the adjudication records that are out there on the internet. But I still think it's super important that you get that expert testimony because it is really difficult for USCIS to make a reasonable argument that you are not at the top of your field if bona fide experts whose qualifications are uncontrovertible are saying that you are a top expert and are saying that you are part of their group. So if you have expert testimony where your experts are saying that you possess extraordinary ability, that you are a top expert in X, Y, or Z, and that you are seen and you are visible as being at the top of your field, that's really good evidence for the case. So for final merits, I usually end up emphasizing the anchor criteria. Then I emphasize the most prestigious aspects of the case. So if you did one journal review that was super prestigious, I'll put that in final merits. And then I'm doing expert testimony saying this expert affirmed that he was at the top of his field. I'll say this top professor affirms that she has visibility at the top of her field and that she's known by anyone who works in this field for her accomplishments in X, Y, and Z. I think that's really, really important for final merits. All right, so it's short and sweet. We have time for a lot of questions here on the live stream. If you do have questions, while you post questions, I'll just go into what happens if you get a challenge on final merits. There's a few different ways it can go. So first, USCIS can issue an RFE. Maybe they'll grant you one criteria or two criteria, but then they'll issue an RFE asking you to prove the rest of the criteria. And then at the very end of that RFE, they usually put in a blurb about how it's your responsibility to prove the final merits of your case. It's never a long analysis in the RFE, but you do need to take it seriously. And you do need to provide that additional expert testimony and that additional analysis that shows that you are at the top of your field. Usually you have 3 months to respond to that kind of RFE. And since they're questioning everything, you're redoing essentially a little mini EB-1A again, just to satisfy the requirements. The second way that the government can question this is by issuing a notice of intent to deny, or a NOID. Usually if they're issuing a NOID, they're granting you at least 3 criteria. So they might grant you 3 or 4 criteria. I have seen them grant 5 or 6. I think it's rarer for them to do that. If they only grant some of your criteria, they will do the same thing in the RFE where they'll question a couple of the other criteria. But then they question the final merits more heavily in the NOIDs. You only have 30 days to respond to a NOID, which makes it a lot more difficult. Like the timeline is very, very fast paced. Usually you have to get additional expert reference letters signed. You do have to assemble very significant documentation. But if you can file a strong response, usually the NOIDs are approved. So notice of intent to deny to me is not any worse than an RFE as far as ultimate chances of approval. It's just a different take on the case. The differentiating factor here is usually if USCIS is only giving you 0, 1, or 2 criteria, they'll issue the RFE. But if they're granting you 3 criteria and say that you still don't qualify, they'll issue the NOID. This can also come up at the decision stage. So sometimes, again, USCIS will issue an RFE, and this doesn't appear to be a significant line of questioning. But sometimes you'll get the decision, and they will grant you at least 3 criteria, and then the only reason for the decision ends up being a final merits analysis. You can appeal these if you want. You can also do litigation if you want, or you can add additional evidence and repackage and refile the case. Those are the general options if you get annoyed. It's challenging, I think, to overcome annoyed. Is definitely emotionally nerve-wracking and all of that, especially given the short timeline, but they are overcomeable. So I don't tend to advise that people give up when they receive those. Just make sure that the attorney you're working with, it is already automatically going to take on an RFE or an NOID when you get it. I've seen a lot of people scrambling at the last moment because they're negotiating what it's going to look like, if the attorney is even going to take it forward, and you don't have time to do that. When you sign on with an attorney, you do need them to guarantee that they will move the case forward if it is challenged, so that you don't have to negotiate a whole separate contract at that stage. It's not good to negotiate a separate contract at that stage. I will also say, sometimes I will take over RFE representation. Not always. I can't do it right now because we have too many RFEs due in September. Sometimes I will, though. I can't ever take over representation at the NOID stage, though. There's just not enough time to get familiar with the case and to present a strong response. So I've had a couple people recently who are contacting me saying, my NOID is due in 2 weeks. I need you to represent me. And that's impossible. So if you're in that situation and you don't feel like you're getting good representation, it is better just to withdraw the case and then refile it at a later point. All right. Jason, any questions or anything that you've seen come up just in the day-to-day about final merits?
So a lot of people seem to think that if an activity doesn't count towards any of the criteria, it automatically counts towards final merits.
Yeah. So that's where I'm saying that, putting in random awards or random media pieces or anything like that that don't count toward the criteria, don't even bother putting those in the final merits. Unless they are objectively prestigious on their own, they really don't count. As far as extraneous activities that I would put in the final merits, sometimes people have really strong keynote conference talks, or they have odd things in the profile that won't exactly match any criteria. I've had, odd cases where we might want to argue the exhibitions criteria, but since it's not for an artist, it would have to be comparable. So instead of arguing it as a separate criteria, I would put that evidence in final merits, because all of it was really, really strong as far as the person's reputation was concerned. So I'm not necessarily saying don't put anything extraneous into final merits. I'm just saying be very choosy. If something is not objectively really strong on its own, I wouldn't put it in the final merits argument section. I would only focus on extraneous things that are really strong, like a top keynote speech, some kind of presentation, exhibition, or something else that doesn't neatly fit in the criteria.
So is there ever a place for this extraneous evidence? Or should everything also help with the final merits of your profile?
There's a place for extraneous evidence if it's really good evidence, but if it's extraneous evidence, it's not really strong, and it doesn't fit in the criteria, most of the time I just leave it out of the case entirely. Like occasionally I'll use it to bolster leading or critical role or original contributions, but only if it fits there. You don't need to put everything into your EB-1A case. I work with a lot of people, and a lot of times what I do is I'm editing it down. And I'm saying, don't include this. It doesn't do you any favors. Like, yes, I know a lot of work went into it, but it's not actually that prestigious. So just leave it out of the case.
Should I put recruiters contacting me into the final merits?
Not usually. Like I have had cases where I've worked with some really like expert consultants, top of their field, 20 plus years of experience, who had projects where they had driven really specific results. And so they were being contacted by headhunters and recruiters for very specific projects at very top companies to replicate those results. Like, so it wasn't that a recruiter was contacting you to fill a role or anything. It's more like a headhunter was doing really specific research to find the top expert in a very particular thing, and then trying to get them to onboard for that very specific project. It is really rare to encounter that kind of situation. So in general, this evidence should not be put into the final merits. But in some cases, I have done it at least a little bit in the past.
So with profile building in general, should you always be focusing on whether an activity will count towards final merits?
No, not always. It's really important for you to meet the criteria. So things come up all the time. For example, I know there's a lot of talk about the Globee Awards and judging the Globee Awards and all of that. It's still a viable way to get the judging criteria checked off your list. So I don't necessarily discourage it. It's not good for final merits. Like, it's really not doing you any favors to point to you being a top expert in the field, but it still might be a worthwhile activity just to get judging checked off the list, to expedite and accelerate your activities in the judging category and all of that. So no, you don't have to look at final merits for every activity you do. However, you do need to remember that final merits is important. So while you're doing profile building, make sure that it's not just focused on the number of activities you get done. Make sure that you are actually constantly pushing forward to get more and more prestigious opportunities, because you will need to highlight at least a few that are prestigious to pass a final merits analysis. It's not a pure numbers game. You really do need those qualitative aspects for the profile.
How much expert testimony should I put in final merits?
It's a good question. So there's no requirement. There's no real standard number of expert letters or anything like that. Typically in my cases, I'm doing 5 or 6 expert reference letters. And so I am putting in quotes from 5 or 6 people about the person's reputation and overall expertise in the final merits section.
Published an article that explicitly talks about the utility of my proposed endeavor in a niche magazine. Got a message from the CTO of a related company saying they're interested in my work.
Yeah, so I'm not sure if this is in the EB2 context or EB1A. It looks like, so he just followed up with another note.
Can I put that LinkedIn message in my NIW petition?
Yes. So when you're doing an NIW petition, looking at the overall merits of the case, it would be helpful, I think, to include that. So definitely include the article. I would probably include that under prong 2, where you're talking about how you are well positioned to advance your proposed endeavor, because USCIS has been advancing a claim that you really do need original contributions of major significance under that prong. And so talking about how your proposed endeavor will do these certain things for the USA, and then showing that there's active interest in actually having you do those things for the USA would be good under prong 2. So yeah, print the LinkedIn message, go ahead and put it in. It's even better if you do actually end up collaborating with the CTO so that you have more documentation and more evidence. But yeah, overall, it's a positive thing for the case.
I was asked. EB1A trends.
Okay. Charan, just let us know if you have any particular EB1A trends that you want to hear about. We just talked about maybe there being a trend on questioning final merits. I haven't, again, seen that in a significant way, but that seems to be what all the chatter is about among everyone else right now. All right. Jason, is there anything else you think we should cover for final merits? We can see if there are a couple more questions come through, but that's my summary for it. I think these are some good points to keep in mind as you're doing the EB1A profile building. But yeah.
How many pages should the final merits be?
Again, there's no rule or requirement about this. I actually like to keep it as short as possible because it's supposed to be a summary of why you are important. So we usually do 1 or 2 pages with quotes from expert testimony and then an additional page of explanation. So normally mine are 2 to 3 pages long. I've definitely seen people do like 50 pages. So there's no standard format. And that's important to keep in mind. There are many pathways to approval. There is no standard format for an EB1A.
Averagely, how many publications and peer reviews put you in good standing of EB1A approval?
If you're using authorship and judge as like the core of your case, you're going to want a lot. So dozens of publications, hundreds, if not thousands of citations, hopefully thousands of citations, that kind of thing. For peer reviews, you want dozens, like 50 plus is better. I've heard firms say 200 plus is better. Again, if these are the core criteria, your anchor criteria, that's probably what you need. But you can get away with a lot less for publications and peer reviews if your expertise is really found in other criteria. So if you are performing a leading or critical role, of course you're not focusing your whole work on publishing or judging. You would only need a few articles and a few judging instances because your claim for extraordinary ability and your claim for expertise is in your critical role. So it really depends on the case. It depends on the type of case. It depends on the field that you're in. Cancer researchers need a whole lot more citations than fundamental mathematicians because their papers are cited a whole lot more than math papers are cited. It really depends. And I would caution you not to account for bright lines and benchmarks that much without talking about the individual context of your case with attorneys and then trying to set goals or benchmarks based on your individual profile.
What happens if my O-40 is approved on the basis to use AI to cure cancer, but I changed my job and during the I-485, my job is now to use AI to solve the supply chain? Will my I-140 be revoked? NIW.
So this is definitely something that needs some further analysis. If you said your proposed endeavor was to cure cancer, then your current job is a problem. And you probably need to transfer back into a job where you're focused on cancer research. But it all depends on how you defined your proposed endeavor. Like when I do most of the cases, we're saying that the person is going to use AI and we're just using curing cancer as an example of what they might do. And so it's a little bit more flexible. And they could still get the I-485 approved if they're changing how or the ultimate application that they're using for AI. So your I-140 won't be revoked because you can always go back into a field to cure cancer, but I'm not sure that your I-485 will be approved. You'd have to really go back in and look at it, and this is something I'd really encourage you to talk to an attorney about. You can schedule a consultation with me anytime.
What is a good number of citations to have for EB1A for a string case?
So I think this is the same question as before, like how many publications, how many peer reviews, and it really depends on the type of case that you're filing, what your field of endeavor is. and what your individual circumstances are. So I would encourage you to talk to an attorney about that too.
All right, last question. What happens if I switch job after I-140 is approved under EB1B category and yet to file 485?
EB1B. So the EB1B is employer sponsored. And if you switch jobs, you will need the new company to file an EB1B for you in order for you to be able to file the I-485. You can't file the I-485 if you're not working for the I-140 petitioner when you file it. So be careful with job switching. Either get your new employer on board to file the EB1B, or wait to change jobs until 6 months after your I-485 has been pending.
Do you want to take more questions, or?
Yeah, we can do the 2 more questions and then cut it off here.
I get married after I-140 approval. How do I add her to get green card?
You don't add them to the I-140 process. Instead, you would file the I-485 when your priority date becomes current, and each of you would file the I-485. As long as you get married before you become a green card holder, your spouse will always be entitled to adjust status with you as a derivative spouse applicant.
Quotes, anchor points roundup. Is that a good strategy?
I am not quite sure what this means. So I want to talk to you separately about that.
Can I retain the old priority date?
Yeah. In the case where you're doing a new EB1B, yes, you can request to port the old priority date to the new one. It's definitely easier to do if the EB1B has been approved for at least 6 months, but you can usually port or retain the old priority date.
All right, last question. Will USCIS accept BCS and AI 2030 Sigma Xi Fellowship for membership?
So membership is a hard criteria to be granted. There is no membership, I think, that you can get that is automatically accepted by USCIS. Not even the most prestigious medical fellowships or anything like that. In tech, BCS is pretty good. USCIS tends to accept it. It has a pretty good reputation. The bylaws are pretty good, but there is still room for USCIS to question it and poke holes in it if they want. AI 2030 is very new. I don't know if they're accepting that. I have included it in a couple of cases. I don't really see any issues with it, but since it's so new and since I've been filing cases with other criteria other than membership, I don't ultimately know if it's being approved or accepted. The cases that I used it in were approved, but like the AI 2030 is not the reason they were approved. And I haven't seen what kinds of questions are coming out from USCIS on this one yet. For Sigma Z, it's like up in the air. They could accept it. They could deny it. For me, Sigma Z is like a middle level one where I still think it's worth including in cases, but not quite as good as BCS, and definitely something that could be questioned. And so that's true of most memberships. Just keep that in mind if you're building towards the membership criteria. Try to pick organizations that are legitimate, that you know have some longevity, that you know are really rigorous, and that you know have good bylaws and all of that. But yeah, hopefully that's helpful. We do have to end the live stream here, but thank you all so much for joining. Hopefully this was helpful to talk about final merits, and I will see you all on Friday.
Thanks, everyone.